The Smith Act was used to prosecute leading members of the Communist Party between 1948 and 1957. Over 100 party leaders were put on trial across the country, most of whom were convicted. The Detroit Party leadership was arrested in 1952 and convicted in 1954 in a trial that reached the pages of U.S. News and World Report that March with the publication of Judge Frank Picard's sentencing speech.
The Smith Act was enacted in 1940, right before we got into World War II, a year before, to protect us against the enemies within. The Smith Act had to do with prosecuting anyone in our midst who advocated or taught or published or edited, or whatever words we would use, to overthrow the government of the United States.
The Detroit case was very significant, not only to this court, the United States District Court here in Michigan, but also to the country.
The trial occurred during the depths of the Cold War, primarily as a product of what was perceived to be Soviet expansionism around the world, especially in Eastern Europe. That's where the Iron Curtain clanked down on those 6 or 7 states in Eastern Europe. That was followed internationally by the victory of the Chinese Communists in 1949, the same year the Soviet Union exploded an atomic bomb.
The fears that came out of the Second World War and the aftermath with the Soviet Union's aggressions in Eastern Europe in particular, the fears in the United States of this international conspiracy led from abroad, but was with a kind of fifth column in the United States, really raised the question, had free speech protections been developed adequately to deal with this new phenomena?
Seldom has free America so resented intrusion and attacks upon its ideals.
And so what we get at home is an explosion against people of the left, and especially of the Communist Party itself.
11 of America's top communists are found guilty of conspiracy to overthrow the government by force.
Along came the first of the great Smith Act trials, the Dennis case, that came in Foley Square in New York City, and that set the tone for subsequent Smith Act trials all over the country.
6 of the defense lawyers received sentences of from 1 to 6 months on 40 citations for contempt of court by Judge Harold Medina. And as it becomes legal history, the Red leaders for the moment reach the end of the line.
The Dennis trial was appealed and resulted in the conviction being upheld and the Supreme Court holding that the Smith Act did not violate the First Amendment of the Constitution. The government treated that as a green light to smash the Communist Party by hitting it everywhere where it had any remotely significant presence. Around the country, among others, a trial of a number of people in Detroit.
We called it the Detroit Smith Act trial.
The defendants were known as the Detroit Six, 5 men and my mother. My father, Carl Winter, had been convicted at the Foley Square trial and was in prison. My mother, Helen Winter, worked full-time with the Communist Party. Billy Allen was the Detroit correspondent for the Daily Worker. Nat Ganley had been the editor of the Michigan edition of the Daily Worker. Phil Schatz was the organizer of the Communist Party section at the Ford Motor Company. Tommy Dennis was the organizational secretary of the Michigan Communist Party. And Saul Wellman was acting chairman of the Michigan Communist Party while my father was in jail.
I was 10 when he was arrested, and it was a big surprise, and there were suddenly big headlines in the paper.
I came home from school for lunch, and my grandmother told me that my mother had been arrested. And I cried. And she said, well, do you think you should stay home this afternoon? And being the trooper I was raised to be, I said no. I wiped my eyes and went to school.
The charge was that they'd conspired together as communists to overthrow the government, this government by force and violence. So the government was trying to show, one, that the communists advocated force and violence, and the word advocate's really important because that's speech. But They were saying that this speech was dangerous. It was like crying fire in a crowded theater, which would create the so-called clear and present danger to make them a threat. After they were indicted, they asked our firm, Goodman, Crockett, Eden, and Robb, to represent them.
We were the first firm in the United States that had a black law partner.
The lawyer that we had in our trial was Ernie Goodman. Ernie was a very, very effective trial lawyer and very highly respected.
Our office could not afford to let any more than one person, me, be in this trial. George Crockett did help in talking about problems. He would talk to some of the witnesses. I had to take, it turned out about 6 months out of my practice, couldn't do anything else.
Fred Case was an insurance defense lawyer. He was a die-hard Republican. I believe it was Eisenhower that appointed him. The trial for the government was tried by a guy named Hundley.
I guess when I came down to the Justice Department in 1951, I was, shared the common belief that, the American Communist Party was very bad, and a threat, and a clear and present danger.
The communists would be tried before Picard. We already had the experience of the government in Foley Square with Medina, and we saw in Picard another Medina. Not only were the defendants going to go to jail, we had to be worried that Ernie didn't go to jail.
About a week before the trial began, was scheduled to begin, the whole 6 defendants came in, and they said they had something to tell me. I said, what is it? I said, well, we have made a decision that fascism has come to America, and that there is no point in pretending that you get a fair trial in this court, in this kind of a case. So our job is to expose fascism in that courtroom. And that's what we want you to do. I said, in the first place, I do not agree with that. I don't believe that fascism has come to America. And one of the ways which I agreed to defend this case was to try to show in that courtroom, that's what's on trial here, is the First Amendment. That's what's on, not fascism. We're trying to save the First Amendment. Freedom to think, freedom of speech, freedom to organize, freedom to assemble, freedom of political belief. We all agreed on that. That's been our strategy. Now you want me to reverse the strategy. I can't do it because I don't believe it and I refuse to accept that. And I will not do it. And therefore you'll have to get another lawyer. Next day they came back. They said, here's what we've decided. 3 of us will be your client. The other 3 of us will try the case as our own attorneys. I think that's a foolhardy thing to do. It worked out very badly for the defendants.
So we had our trial, and the trial is a 4-month trial. It's very serious. The whole community is involved. Every day that the trial took place, there were headlines in the Free Press and the news. Every day.
The jury was an impossible jury. And there was no jury, we felt after we saw who they were, that you could get, with possibly a few exceptions, who would have a chance even of a hung jury. There was one woman who had an excellent university education, but she was a resident of Grosse Pointe, member of a fairly wealthy family. They said, no, we only want workers, working people on our jury. They said, don't you realize there's more prejudice among the working people on the issue of communism than in almost any other circle?
It was necessary for the government to prove that the defendants had conspired to teach and advocate the violent overthrow of the government with the knowledge that the organization they created, the Communist Party, was in fact committed to that kind of an objective. Now, what the defense attempted to do was, in the first place, to establish that the Communist Party was not that kind of an organization. They simply accused the government of mischaracterizing the organization that they had formed to advance their political objectives. The witnesses used by the government were of two types, rather unappealing to many people. One of them was informants who had operated within the Communist Party and who then appeared on the witness stand rather dramatically, often shocking the communist defendants who had regarded them as good communists and friends.
We would review all of the informants' written reports to the FBI to decide which ones we wanted. And I would read those endlessly, and they would be talking about civil rights, they would be talking about the poor, they'd be talking about unemployment, they would be talking about socialism being better than capitalism. You know, whether you like that or not, you know, it's certainly perfectly legal. After all, we were charging them with conspiring to teach and advocate the overthrow of the government. And I always remember I came across one of these reports, and I'm reading it, and it's the usual. They're talking about the unions or something like that, and some guy stands up at the meeting that's in the report, and he says, let's cut out all this nonsense. When are we going to start the revolution? So I'm a young lawyer. I get all excited. That's the kind of evidence I want to use at the trial and whatnot. So I go to the FBI, and I say, I want that. And they all huddle, and they come back, and they say, listen, Bill, we can't have that, because that guy who jumped up at the meeting is one of our informants.
And lo and behold, what they have found out is that the Ford Motor Company was really carrying on spying activities within the Communist Party against union organization. And that's not good. That's not good for the union. And we succeed of forcing the head of labor relations at Ford to be called into the courtroom to tell the story of what they had been doing. And the next day, the entire leadership of Ford Local 600 comes into the courtroom. It must have been about 35, 40 people. P.S. It didn't help us.
And the other kind of witnesses were people who had operated for a number of years essentially as professional witnesses, earning their livelihood from testifying against communist defendants in not only Smith Act trials but also in hearings before the House Un-American Activities Committee.
You had to really look very closely at the testimony and allegations of what became professional informers. They would move from place to place. It was a circuit. It was like going on a lecture circuit. And once you established that you could be a witness at one of these trials, you had a source of income.
John Lautner had been a significant internal functionary in the Communist Party, and he was the crucial government witness in these prosecutions. He was, because of the position he held in the party, able to give a great deal of very detailed testimony about the structure of the Communist Party, about its internal operations, and about its objectives, all of which served the government very, very well and were very, very damaging to the communist defendants.
So I was a pro se, so on a number of occasions when I would get up to speak, I would proclaim my communism, my fealty to communism, and how proud I was to be a communist. And every time I did that, Judge Picard would call me into his office in the back. And he would say, I don't understand you, Mr. Wellman. Every time you open up your mouth and you say, I'm proud to be a communist, you get a conviction. So I says, well, that's an occupational problem.
Our evidence, the government's evidence, were all these books, these Marxist-Leninist books. You know, we used to read the inflammatory passages to the jury. And, you know, those books were in all the libraries, you know, whether you agree with them or not. And that, you know, that was the basis of the government's evidence, all these books.
Disjointed quotations yanked out of context from a series of old books going back to the Communist Manifesto in 1848.
My mother had phlebitis, and she was on bed rest. She was certainly not supposed to walk. And the trial required that she come to court. At first, she came to court by ambulance, and the ambulance attendants brought her up to the courtroom on a stretcher with a red blanket across her, which I understand is the way all ambulances kept their patients warm, with a red blanket for emergency. Judge Picard threw a hissy fit and ordered the red blanket out of his courtroom, indicating that it was some kind of political maneuver.
The question which came to mark the decade,
have you ever been a member of the Communist Party?
The next question, by the way, would have been, who else was a member with you?
And we had that policy, you know, we were supposed to get these guys to name other communists. And I'm the one that cross-examined Wellman, I remember this. And I followed the policy with him. I tried to get him to name some person who taught at a communist school. I knew he wouldn't do it, you know. And I knew if he didn't do it, that Picard, the judge, was going to put him in jail, you know, which he did. He put him in jail for 60 days, I think, because he wouldn't be a fink. I mean, that, you know, whoever this teacher was totally irrelevant. He did it with one other defendant, Schatz, and then I wouldn't let him do it to the other defendants. I wouldn't let him do it to Dennis when they all testified. I said, stop, I'm not going to let you do this anymore. Yeah, I really was ashamed of that. Yeah. But he was, you know, he was Mr. Tough Guy. I knew he wouldn't answer it.
If one looks over the charge that Judge Picard delivered to the jury, the law as laid down by the Supreme Court, a law which Judge Picard had to follow, very much favored the government. And so if Picard simply laid out what the law required and then said what evidence the government had presented that supported that position and what evidence the defense had presented that refuted it, the inevitable impression was going to be that this was a trial which favored the government.
It was a difficult trial because we had persons that were representing themselves. That always made it more difficult. We had persons that were staunch believers in what they were doing and why they were doing it. But I think under all of those circumstances and having tried those kinds of cases, I think that Judge Picard did an outstanding job under very, very adverse conditions. My understanding from all of the anecdotal kinds of things in this building was that he did a great job on that.
If you're waiting around, as you do when a jury is out, and I came into the courtroom at one time, it was absolutely empty. I was looking around at it, you know, and having no sense of any chance of winning the case at all. And as I was standing there, out pops from the door Judge Picard with his robe flowing, and his hair flowing, and long white hair. And he sees me, and he stops. And I look at him, and he walks over. He looks at up to me in my face, and he says, "Ernie, you know, I think they may acquit them, do you know? Do you think so? You think that they might?" he was asking me to give him some solace and comfort. I look at him and I said, this is too much. Can't believe it. I put my arm around his shoulder like this. And I said, Judge, I said, don't worry. They'll all be convicted. He looks up. He says, do you think so? I said, yes, they'll all be convicted. He said, oh. He turned around and walked back to this room. An hour later, they came back and convicted them all.
I remember my father seeing him in the hallway in handcuffs, and it was a terrible thing.
Judge Picard began his sentencing statement with, well, it is not my desire to prolong the embarrassment this morning or abuse you as some people might desire. There is no satisfaction and seldom anything accomplished by kicking a man when he's down. And you people are down. Now I'll tell you this. I have the power to change my sentence. Any sentence I give today, within 60 days, and if any of you would like to go to Russia to live, I can arrange it. As I said to you in the charge, you can believe anything, even that we ought to have a monarchy in this country. But you can't force those beliefs on others by force and violence. So you're not martyrs, you're goats, and Russian goats at that.
The case went from here to the Sixth Circuit Court of Appeals that sits in Cincinnati, Ohio. In the Court of Appeals, in this particular case, the defendants lost. They then petitioned the United States Supreme Court.
A few years after that, the appeals were continuing and such. I had gotten an American Legion Award for citizenship or something. The daughter of this communist leader who was on trial and had been convicted got this award for Americanism. So it was played up in the press as a big thing, and it went all over the world.
Okay, tremendously significant for the Detroit case was a Supreme Court decision called Yates versus the United States, handed down in 1957. The court said that the Smith Act could constitutionally be applied to advocacy of action, but not to advocacy in the realm of ideas. That made it necessary for the Supreme Court to reverse and remand the cases that had already reached it.
The Yates decision is the beginning of the Supreme Court's backing away from the implications of the Dennis decision. I think the change from Dennis to Yates is a product of the sense of embarrassment, the sense of having lost our way.
The Court of Appeals received the case back from the Supreme Court, and it reversed and remanded the convictions obtained there, which meant that it was giving the government the opportunity to retry the defendants. Now, as it turned out, the government never did retry the defendants.
There are some who say that the fact that the government did not pursue a second trial after the Supreme Court cases, and that all over the country other communists were not tried, suggests that ultimately we regained our senses and we righted the wrongs. But what about the years people spent in jail, broken lives, people in hiding, inability even after 57 perhaps to earn a living with people who were, oh, you were the guy in the spy case, weren't you? Even if in fact you had been exonerated.
It was very difficult being a kid to grow up in a time like that. And one of the other things that we grew up with feeling was that we were really different, because in that era there were no political prisoners in this country. That's what everybody grew up believing, and we were part of a political prisoner family.
You know, looking back, I mean, obviously, I am not proud of the fact that I was the prosecutor in those cases. I don't even put it on my resume, quite frankly.
So it's a reminder of the importance that you shouldn't confuse dissent with disloyalty, and the importance of protecting the Bill of Rights.
The Wallman case was really about free speech, and that's what the justices spoke about in the Supreme Court, and that was really the bottom line. And it's interesting because every constitutional issue kind of comes around and goes around. Not only the First Amendment, but almost every single one that I've seen since I've been a lawyer and a judge, both in the state system as well as the federal system, comes around. And what we're seeing today, after 9/11, it's very, very interesting because we're seeing First Amendment cases and people speaking and being penalized for what they have to say.
And then the question is, what will the courts do? Will the courts say, we went through this before, we made a mistake in Dennis, we're not going to do that again, and we will not allow it, even though people believe that this is entirely reasonable? Or will courts do what they have done in the past many, many times, which is themselves to succumb to the kind of paranoia and fear that leads to these terrible injustices? And then once again we will be embarrassed, and once again we will go through a period. That's the great question, I think, for our time.